saying that. What I'm submitting, Your Lordship, is that the judgment which went up, the matter which went up to the apex court.
Please answer to the court
So
question.
there is no specific power.
Wanted to ascertain who was the competent authority at the relevant point of time.
Once fresh issue, my lord, comes up as to whether, my lord, what is the document where under, my lord, it has been made constituent.
Is he appearing for university?
Registrar.
These daily wage and other issues are cropping up 2 decades back. Why the audit has not raised objection? If their appointment is illegal, what action you have taken against the principal? Let them consider the criteria laid down in the Uma Devi case.
That, Your Lords, in my respectful submission, is at page 96.
Sir, we don't know. It is a factual aspect which is required to be examined by the university. Whether do you fulfill the 4 criteria or 3 criteria? Budget allotment was allocated in respect of meeting the expenditure in respect of ad hoc employees. Why such objection was not raised at the relevant point of time?
Lord, Your Lordship may kindly recollect, Lord, on the previous date when I was appearing, Your Lordship has been pleased to direct, Lord, the authority from the Education Department who is well known, well versed with the affairs, and the University Authority, my Lord, to be present, my Lord, to assist. And in command thereof, my Lord, Registrar General of the University and Deputy Director Higher Education is in attendance, Your Lordship.
Yes, sir.
Lord, they are appearing, Your Lordship.
Question is whether principal of JP College is empowered to appoint
Yeah.
respondents or not.
Yeah.
Where is the source?
Lord, before they make submissions, my Lord, and assist Your Lordship, I refer to only the relevant law, my Lord, of the University Act.
What is their date of appointment? What is their date of appointment?
कहाँ गया? My Lord, 1988-89, Lordship. And prior thereto, my Lord, kindly have the pleasure to record this much. 1976-1977, the college, my Lord, had become constituent. 1976-1977, college has been made constituent.
College has been
Made constituent. It is, my Lord, becomes, my Lord, the government college. Every expenditure, everything, my Lord, is incurred by the university, my Lord, pursuant to the aid granted by the state.
then who is
1988-89, my Lord,
they were appointed on daily wage.
daily wage. And thereafter, Your Lordship, thereafter, my Lord, the Vice Chancellor rejected his application, my Lord, for regularization, and against that, Your Lordship, the petition was filed.
Sir, who is the appointing authority?
Appointing authority, my Lord, is the Vice Chancellor. My Lord, may I refer to the relevant provision of the law. And thereafter, they will like to assist, my Lord, because they have been summoned.
Which volume, sir?
Pahla. Section 10, the Vice Chancellor, page number 13, Your Lordship, of Bihar State University Act 1976. Then kindly come to page number 14, my Lord, clause 5, rather subsection 5, The Vice Chancellor shall be the principal executive and academic officer of the university, the chairman of the syndicate and academic council, and shall be entitled to be present and speak at meetings so and so. Thereafter 6, Your Lordship. The Vice Chancellor shall, subject to the provisions of this Act, the statutes and the ordinances, have power to make appointment to posts within the sanctioned grades and scales of pay and within the sanctioned strength of the ministerial staff and other servants of the university, not being teachers and officers of the university, and have control and full disciplinary powers over such staffs and servants. Thereafter, Your Lordship will find proviso. Perhaps the Lordship may not like to read, my Lord, because it has been introduced, incorporated, my Lord, pursuant to amendment, my Lord, with effect from 31st of March 2021. And that all they have been appointed much earlier. That's why proviso may not apply. Thereafter, my Lord, mildly come to, my Lord, the registrar, section 15, page 19. Subsection 2, my Lord, the registrar shall be whole-time officer of the university and he shall act as secretary to the Senate, Syndicate and Academic Council. And section 15, subsections 2 at page 19. The registrar shall be whole-time officer of the university and he shall act as a secretary to Senate, Syndicate and Academic Council and shall, thereafter next page, Your Lordship, D, represent the university in suits, Lordship, what?
Yes.
Represent the university in suits or proceedings by or against the university, signs power of attorney and verify pleadings or depute his representative for the purpose. And thereafter G, my Lord, with respect to disciplinary power. And against that, my Lord, his order, my Lord, of the registrar, appeal, my Lord, lies subsection 3, a small a, appeal lies to the Vice Chancellor. Thereafter, my Lord, there used to be Senate, Syndicate, but those are not relevant for the moment. And thereafter, kindly come to, my Lord, section 35 at page 33. Section 35 at page 33, Your Lordship.
35.
Section 35 at page 33, my Lord. No post for appointment shall be created without the prior sanction of the state government. Notwithstanding anything contained in this act, no university or any college affiliated to such a university except such college as is established, maintained or governed by the state government or as is established by religious or so and so, so and so. Not very relevant, my Lord. Thereafter, my Lord, then my Lord, it is, my Lord, part 2 of the same book. After page 846. After page 846, my Lord, part 2 starts. Not got it.
Yes.
It is, my Lord, general conditions of service of employees of the Patna, Bihar, Ranchi, Bhagalpur, Bhagalpur, Magadh, LN Mithila and KSD Sanskrit University. Then kindly come to one page thereafter, my Lord, internal page 3 thereafter, my Lord. Internal page 3 there.
Page 3.
3. बस एक पेज के बाद. Your Lordship, after about 10 lines, my Lord, Your Lordship will find heading appointment. Lordship got it.
Yes, appointment.
Yes. Then, my Lord, kindly come to clause 3. Whenever a permanent post in any grade and pay scale is available for substantive appointment, the claim of university servant who has been holding a tenure or temporary post for not less than 2 years and possesses the requisite qualification prescribed for the post and his work is found to be satisfactory may be considered for the first instance of for substantive appointment to that permanent post, and thereafter, my Lord, B, in case of post-temporary tenure appointment which the employee is holding must have been made in accordance with the provisions of the Act and the statutes. Lordship got it. I would be emphasizing this. B. And thereafter, next page, Your Lordship, how vacancy, my Lord, is to be processed.
Where is the word constituent college?
There is no word as such.
Then how do you say that this is applicable to the constituent college?
It is applied, Your Lordship.
Then you have to
covers,
where is the word constituent college?
it applies to all colleges, my Lord.
Correct, but you are distinguishing the constituent college
Why I am saying constituent college, in affiliated colleges, my lord, the appointment power is vested with the, my lord, the managing committee. That's why I have said. There is a distinction between.
I mean to say this constituent college is a government college? Government college.
Lordship, may kindly see, my lord, section. Page 2 of the, Lord, then kindly come to page 2, my lord, of the act, your lordship, at the initial.
Yes.
I. Constituent college means a teaching institution maintained or controlled by the university. Entire expenditure
No.
will not be funded by the state. And there,
There is a R.
huh?
Teaching institution maintained.
Or controlled by the. Not maintained.
Maintained by the college itself. Maintained by college itself.
Maintained by the university or controlled by the university.
What is this R?
Or, my lord, only, my lord, says, my lord, either it is maintained or controlled by the university.
Sir, that.
Any teaching institution.
No, in view of this clause I, where is the any order of the university that we are going to control this institution?
It is, my lord, taking over takes place, your lordship.
Correct. On what date it was taken over?
These are not the pleadings.
Those are all the crucial matter which required to be examined
Then
in order to identify who is the.
One thing, Lord, may I suggest one thing? I have today morning also, my lord, I have talked to the university vice chancellor. I'm sorry, honorable vice chancellor, your lordship, and he has suggested something, but those are not on the record. And learned registrar is in attendance, my lord. He has prepared, my lord. His assistant has prepared, my lord. Legal cell assistant has prepared something, which are not part of the record also, my lord. In certain facts which are the part of the statement of fact prepared by them, it is also not part of the record. If your lordship will grant, my lord, or direct me, my lord, then I can, my lord, give the chronological data when.
Why you want all judicial order? So moto you take action and produce material.
Take care. Under the but under the guidance of the vice chancellor.
Do whatever you want, sir. Why are you taking adjournment now and then?
I am not taking urgent.
Then you are taking. Now we are asking you.
My lord,
In terms of this, who is the?
since your lordship, these are, my lord, not in the question in issue, and that's why your lordship may not find.
Question is simple, sir. Whether principal of that college is empowered to appoint or not.
Then-
Now you say that reading of all these things, power is vested with the university. Now in terms of this there is a clause. Institution can be maintained on its own or by university.
No, it is to be maintained. Constituent means, my lord, maintained or controlled.
Read once again, sir.
Yes.
Read the definition of constituent college.
Constituent college means a teaching institution maintained.
Stop at that. That is one portion. Or controlled by the university. If it is controlled by the university, where is the document to show that it is controlled?
It is, my lord, I will explain, lord. Institution maintained or controlled by the university. Either, my lord, the university maintains it or controlled it. This is the interpretation of this.
Correct. Now we want to know whether control is there or not.
Yes.
Show us the document.
Once, my lord,
Show us the document.
once your lordship, my lord, it is, my lord, constituent college made, my lord. How it is, how the.
Where is the document to show that it's a constituent college? Where is the document to show?
Those were not in issue, and it has been accepted, my lord, that it is a constituent college. That's why, my
All right, we will say that there is no cooperation. We will dismiss your petition.
lord, since your lordship, this was
You may-
not in issue.
You may not have dispute. This court wanted to ascertain who was the competent authority at the relevant point of time.
Once fresh issue, my lord, comes up. As to whether, my lord, what is the document where under, my lord, it has been made constituent, and that amounts to control by the university. My lord, that has to be produced, because unless and until, my lord,
Who has prevented you to produce, not to
there
produce?
was no need of it to be produced.
Therefore, we will pass order. There is no coordination. We are going to dismiss your petition.
Please don't.
Every time one or the other issues will be raised, you will be asking time.
This is not an issue at all. What I am submitting, my lord, in nutshell, my lord, the very, my lord, premise of my submissions are, my lord,
The order sheet.
limited.
More than your petition.
Yes, very limited submissions I am making. What I am making submissions, my lord, is that the posts were not.
Sir, next time we will not adjourn. Don't ask time. Do whatever you want to place it on record.
Because for this.
It is high time.
Your lordship has been-
Keep on adjourning the matter.
No, I am not asking for adjournment, since your lordship is.
All right, you are not asking, then we will pass orders.
Since your lordship, I cannot insist for that. Since your lordship is, my lord, asking as to what is the instrument where under, my lord,
Sir, because of your submission, that it is a constituent college from 1976 to 77, is it not your duty to bring it the notification or order?
statement has been made, documents.
Your statement is not sufficient, sir.
Then
You have to produce the record.
Whatever reasonable time your lordship desires, my lord, I will bring it on record. The only is, I'm sorry, lordship.
Sir, please understand. Look at this. Your order sheet
I understood.
runs more than your petition.
Section 10(6).
Word may not be incorporated in the regularization order. The question is, principal is competent. As on the date of constituent term.
What would be the reason they should?
Otherwise, what action they have taken for this? How the budget is being granted?
Who is appearing for university?
Registrar.
These daily wage and other issues are cropping up 2 decades back. Why the audit has not raised objection? If their appointment is illegal, what action you have taken against the principal?
We appointed registrar, sir.
Huh?
I am newly appointed registrar. 6 months ago.
6 months ago. So you don't know what is the picture.
I know something about the ex-registrar. This is the letter related to there is power of university.
Then who is responsible? Who is answerable to this court? Who is answerable to this court? If you are assuming the charge of the registrar today, so we should not ask earlier period what happened and other things. Are you not required to answer? Huh? Are you not required to answer?
So I am trying my best to answer that there is no power of college to appoint any.
Correct, sir. What action you have taken against the principal? Why the audit has not raised objection? How the budget allotment was allocated in respect of meeting the expenditure in respect of ad hoc employees? Why such objection was not raised at the relevant point of time?
My lords, I represent the writ petitions. My lord would permit me a few minutes to demonstrate the fact that the principal was the competent authority
Please.
from the pleadings in the writ petition itself.
Not pleadings, we want documents.
Documents in the writ petition.
Documents only,
My
no
lords will permit me to kindly place my annexure 14 of the writ application.
writ application.
This issue, your lordships, with regard to the powers of the principal under subsection 6 of section 10 is no longer res integra in view of the judgment of the Honorable Supreme Court. It's a reported judgment. Page 55 of the writ brief, my lord, would kindly permit me to place the 2173 of 2008, out of which this LP arises. Page 55, your lordships, annexure 14.
What is the date of this document?
14/5/1977. The syndicate, my lords, delegated the powers to the Vice Chancellor, and my lords will kindly come to the relevant portion on the next page, page 56.
Now, what is the heading of this? Where is the power of appointment is?
Yes, I'm coming, I'm there for next page, my lords, next page. My lords, kindly bear with me. On the next page, appointment of the third and fourth grade employees, my lords will see.
Yes.
Subclause 1, for all such posts in the PG and the constituent colleges, head of the departments, oblique principals of the college concerned, subject to the approval of the Vice Chancellor and oblique or the syndicate. This, my lords, was issued on 14/5/1977 itself.
This rider clause has been complained.
My lord will, yes.
Subject to approval of
My lord
Chancellor.
my lord will kindly come to annexure 2 of the same writ application, my lords. There was a public advertisement made by the principal. At page, my lords will kindly see at annexure 2, starting page 20. जयप्रकाश महाविद्यालय नारायणपुर भागलपुर विश्वविद्यालय भागलपुर विद्यालय में निम्नलिखित पदों के लिए विज्ञापन निकाला जा रहा है. There was an advertisement issued by the principal, my lords, way back in the year.
No, advertisement, all right. Whether your appointment has been approved by the Vice Chancellor or the syndicate.
Pursuant to the orders of the Honorable Single Judge, the university themselves have confirmed our appointments. That is on record in the LPA itself.
Where is the document of the approval?
My lords will kindly permit me, page 96
96 of the memo.
96 of what?
of the memo of appeal bills.
Running page 96.
Which your lordships have already taken note of in your lordship's last order.
The part here.
हमारे LPA के counter का.
Page 96.
My lords, Election-
72.
your lordships please, of 2012. May I place it, your lordships? My lords, pursuant to the orders of the Honorable Patna High Court passed in CWJC number 2173 of 2008, this is the writ application against which the LPA has arisen. The services of the following petitioners, third and fourth grade employees of JP College, Narayanpur, a constituent college under TM Bhagalpur University, are regularized against vacant sanctioned posts from the initial date of the joining of the college mentioned against their name. As per direction of the Honorable Patna High Court, Principal JP College, Narayanpur is directed to accept the joining of the petitioners and send the claims of their salary at the earliest so that it may be sent to the Education Department for release of funds. So all 10 petitioners, then my lord would see by order of the VC. The registrar of the university has issued this order.
So they have complied it. They have complied the.
The order of the Honorable Single Judge, my lords, stood complied on 5/3/2012, more than 2 years before the LPA came to be filed. There is no right.
Yes, sir.
And my lords, what my learned senior friend appearing for the appellant has been submitting with regard to the powers under subsection 6 of section 10. If my lords will kindly permit me to place the judgment of the Honorable Supreme Court.
No, before that, where is the delegation of power? Vice Chancellor is empowered to delegate.
My lords, my lords, we are grade 3, grade 4 employees. The syndicate, I have shown
All right, sir. Now the Vice Chancellor has given, is empowered, has delegated his power to the principal, no?
My lords.
Where is the such power?
My lord, therefore, I was referring to this judgment because
Not judgment, you have to establish from the statute.
the same issue was raised before the Honorable Supreme Court.
In this, there is a power or not?
My lords, under section 23C, the syndicate has powers with regard to overall control of the university.
Sir, delegation of power to the, any other authorities.
The-
Where is the Vice Chancellor power, the powers and functions?
My lords, by the letter of 14/5,
Sir, where is the powers and functions of the Vice Chancellor?
Ten.
10/6, my lord would have a look. And the same section 10 subsection 6 has been interpreted by the apex court with regard to constituent colleges.
No, it is not delegation of power.
No, there is no, I'm not saying that. What I'm submitting, your lordship, is that the judgment which went up, the matter which went up to the apex court,
Please answer to the court
so
question.
there is no specific power. I have to concede that.
Then wait for some time. You consider, but don't directly go to the judgment.
No, because the same issue cropped up before the apex court.
Sir, first we have to examine.
I concede that there is no power.
There is no power.
There is no power.
Then
Yes. Then my lord would see that the syndicate in 1977, 14/5/1977, took a decision to give the powers to the principal to make such appointments.
where is the powers and functions of the syndicate?
23. Section 23. Powers and duties of the syndicate. My lord's pleasure to have a look to small c of section 23.
It is not relating to delegation of powers to the principal. Not then. Oh, power, delegation of power. Is jurisdiction. He has not been empowered by the statute, no? He can delegate his powers. There is no.
Yes, sir.
My lords, then if my lord would permit me to place that.
Please.
My lords, it's a reported judgment, lords, citation, for SCC, 2015, volume 8, SCC, my lords, 265, page 265. Amarkant Rai versus State of Bihar and others. My lords, at page 266, para 1 is the issue which fell for determination before the Honorable Supreme Court. Leave granted. My lords have come to para 1.
Yes.
Leave granted. This appeal by special leave arises out of the order dated 22/2013 passed by the High Court of Judicature of Patna and so, which was dismissed in limine by the High Court, whereby the order of the learned single judge was confirmed, observing that the appointment of the appellant as a daily wager was not by the competent authority and he is not entitled for regularization. This was the issue, my lords, which was to be determined by the Honorable Supreme Court. Now, tracing the entire history pursuant to what Uma Devi case has held, my lords, 3 paragraphs of the judgment would be very relevant. 8, 10 and 13. May I place those 3 paragraphs for your lordship's consideration?
Read.
Your lordships, please. Para 8. In so far as contention of the respondent that the appointment of the appellant was made by the principal, who is not a competent authority to make such appointment and is in violation of the Bihar State Universities Act, hence the appointment is illegal appointment. It is pertinent to note that the appointment of the appellant as night guard was done out of necessity and concern for the college. As noticed earlier, the principal of the college by letters dated so-and-so recommended the case of the appellant for regularization on the post of night guard, and the university was thus well acquainted with the appointment of the appellant by the then principal, even though the principal was not a competent authority to make such appointments. And thus, the appointment of the appellant and other employees was brought to the notice of the university in 1988. In spite of that, the process for termination was initiated only in the year 2001, and the appellant was reinstated with effect from 3/1/2002 and was removed from services finally in the year 2007. As rightly contended by the learned counsel for the appellant, for a considerable time, the university never raised the issue that the appointment of the appellant by the principal is ultra vires the rules of the BSU Act. Having regard to the various communications between the principal and the university, and also the educational authorities and the facts of this case, in our view, the appointment of the appellant cannot be termed to be illegal, but it can only be termed as irregular. Then, my lords, para 10 on the next page. As noticed earlier, the case of the appellant was referred to a 3-member committee, and the 3-member committee rejected the claim of the appellant, declaring that his appointment is not in consonance with the ratio of the decision laid down by this court in Uma Devi 3 case. In Uma Devi 3 case, even though this court has held that the appointments made against temporary or ad hoc are not to be regularized, in para 53 of the judgment, it provided that irregular appointment of duly qualified persons in duly sanctioned posts who have worked for 10 years or more can be considered on merits, and steps to be taken as a one-time measure to regularize their appointments. Then, my lords, comes para 13. In our view, the exception carved out in para 53 of Uma Devi is applicable to the facts of the appellant's case, of the present case. There is no material placed on record by the respondents that the appellant has been lacking any qualification or bore any blemish record during his employment for over 2 decades. It is pertinent to note that services of similarly situated persons for daily wages for regularization, who was appointed on daily wages, was regularized with effect from 1987. The appellant, although initially working against an unsanctioned post, the appellant was continuously working since 3/1/2002 against sanctioned posts. Since there is no material placed on record regarding the details whether any other night guard was appointed against the sanctioned post, in the fact and circumstances of the case, we are inclined to award monetary benefits to be paid from 1/1/2010.
Paragraph 15 is the done.
Para 15, lords, the impugned order of the High Court in Amarkant Rai versus State dated 22/13 is set aside and the appeal is allowed. The authorities are directed to notionally regularize the services of the appellant retrospectively with effect from 3/1/2002 on the date on which the post became vacant, whichever is later and without monetary benefit for the above period. However, the appellant shall be entitled to monetary benefits from 1/1/2010. The period from 3/1/2002 shall be taken for continuity of service and pensionary benefits. Therefore, my respectful submission is, my lords, that under similar circumstances,
Do you fulfill the criteria mentioned in the Uma Devi case?
my lords, I do.
Then we'll consider, we'll ask them to reconsider.
My lords, no, we are already there.
All right, we let them consider the criteria laid down in the Uma Devi case.
That, my lords, in my respectful submission, is at page 96.
Sir, we don't know. It is a factual aspect which is required to be examined by the university. Whether do you fulfill the 4 criteria or 3 criteria?
That is why they have issued that letter in my favor.
All right. Then why are you afraid?
I'm not
Then we'll ask them to re-examine. In the light of Uma Devi case, if you fulfill the criteria and as a one-time measure, you are entitled to regularization.
They have already regularized our services.
All right, sir. But the LPA has been filed, no? If their fundamental right, they can challenge the single judge order.
But before challenging, 2 years prior to challenging the order by lords, the university themselves have regularized us without any rider.
Is there any mandatory rider is required to be?
No, what I'm submitting, Your Lordship, is that the fact that they have already done so.
All right, let them undertake one more exercise, whether you fulfill the criteria laid down in the Umadevi case or not.
As Your Lordship, please. My lords, this is almost 9 years. 2012 we have been regularized.
Then we will allow the writ petition on different ground,
No, what I'm
on the ground that vice chancellor and university have no power to delegate, subdelegate the powers.
we should be given an opportunity to represent before they take a final decision.
Yes, that will be given.
My lords, that is what I was submitting.
That will be given. They have to give,
My lords.
because you have to establish your factual aspect, then they will consider.
Regulation वाला कहाँ पे था?
पढ़ना चलो जा रहा है।
And my lords, there was one request, if it finds favor, that they will take into consideration their own order which they have issued.
We are not concerned with that. We are giving you option. One, on the ground, we are going to allow the petition only on the score that vice chancellor is not empowered to
I would take,
subdelegate his power.
I will take the second option,
All right.
subject to my
Yes.
natural justice.
You will be given natural justice.
My lords.
And that regularization, only 1 second, Lord. So regularization was in terms of Lord MJC number 506.
We don't know, sir. We don't know all those.
It is recorded in the order itself.
Correct. Then why did you file LPA? Why did you file LPA?
Because of the contempt threat that was ordered by.
But in the regularization, have you imposed the condition subject to filing of LPA and other things?
Written in the same order, Lord, while regularizing in MJC numbers.
Please take the.
Oblige, lordship.
Matter is urgent from time to time for want of certain issues. In particularly, whether the principal of the which college?
JP Narayan.
JP College, Narayanpur is a competent authority to appoint class 3 and class 4 employees on ad hoc basis or not. Next, JP Narayan College, earlier, where we have mentioned JP College, Narayan College, within bracket for short college. College was converted into constituent college in the year 1976 and 77. The respondents were stated to have been appointed on ad hoc basis in the year 1988-89. Their grievances before the then single judge is the entitlement of a regularization with reference to length of service rendered by each of the respondent in the college. The then single judge allowed the CWJC 2173 of 2008 on 28/3/2011. There was inaction on the part of the authorities whereby respondents were compelled to file MJC What is the number, MJC number?
My lord, it's 5073 of 2011.
Huh?
5073,
5073 of 2000
11.
was filed. So during pendency of MJC 5073 of 2011, respondents' names were, respondents' services were regularized on
53 2012.
5/3/2012. After lapse of 2 years from the date of regularization, state of Bihar presented this LPA questioning the order of the learned single judge. Twister. Next part, learned counsel for the appellant state submitted that learned single judge has not appreciated that power and functions of the functions insofar as appointment of class 3 and class 4 in the college is vested with the university and not the principal. Mr. Learned counsel for the appellant relied on various sections of the Bihar Universities Act 1966, like subsection 6 of section 10, clause within bracket small d of section 15 and section 35, and further relied on subclause 3 of subclause 3 of 3 within bracket part 2. With reference to these various provisions, it is pointed out that principal of the college is not empowered to appoint a class 3 and class 4 employees in the college on ad hoc basis. Per control and counsel for the respondent resisted the aforesaid contentions and submitted that appellants have not apprised this court relating to delegating the powers of appointment to the principal, head of the department / principal, on 14/5/77 within bracket annexure 14 to the CWJC. He has also relied on apex court decision in the case of Amarkant Rai versus the state of Bihar, reported in within bracket 2015 8 SCC 265 within bracket para 8, 10, 13 and 15. Therefore, the appellant state have not made out a case so as to interfere with the learned single judge order. To further learned counsels for the respective parties. No doubt it is true that head of the department / principal of the college is empowered to
appoint class 3 and class 4 employee subject to approval of university officials like a vice chancellor, so, perusal of the records. There is no material information on two issues, namely whether Vice Chancellor is empowered to delegate his powers to the Vice Chancellor, head of the department slash principal or not. Further, assuming that principal of the college was empowered to appoint class 3 and class 4 employee, he or she is required to get approval from the Vice Chancellor of the university or not. So, sir, in this regard, there are no materials placed on record. To stop. Anyhow, in the light of habeas court decision in the case of Uma Devi, having regard to the length of service rendered by the respondents, they are entitled to consider their names for regularization as a one-time measure. To stop. Therefore, the concerned authority is hereby directed to prepare a service chart of the respondent and thereafter verify whether each of the respondent fulfilled the criteria laid down by the habeas court decision in the case of Uma Devi or not. In this regard, if there is any shortcoming of any of the respondent, in that event, a necessary detailed notice shall be prepared and issued to the concerned respondent. Concerned respondent is hereby directed to furnish his explanation along with the material information to the concerned authorities within a period of 3 months from the date of receipt of show cause notice, in the event of issuance of show cause notice. The above exercise shall be completed within a period of 6 months from the date of receipt of this order. In the event of respondent is entitled to regularization, in that event, necessary service and monetary benefits shall be extended to the respective respondents. Next, in the light of the above order, the regularization order dated 5/3/2012 is subject to outcome of passing a fresh order of regularization. To this extent, order of the land single judge is required to be modified. To step next file. When counsel for the respondent cited Amarkant Rai decision, no doubt in that decision it is held that principal, who may not be a competent authority, however, whatever the action taken by him has been treated as irregular. Therefore, the respondent's service condition would be almost identical to that of Amarkant Rai. Therefore, we are compelled to ask the concerned authorities to revisit their regularization as to whether each of the respondent fulfill the criteria laid down by the apex court in the case of Uma Devi so and so. Accordingly, LPA is allowed in part.
Thing, the state
if
authorities
Lordship
are
grant
aware
me
of the
liberty-
fact that respondent number 5 is no more. We have brought that on record, we have not substituted him. So that may be clarified.
Fifth respondent.
Fifth respondent, Lord. The legal heirs of,
At this stage, fifth respondent is stated to have died during the pendency of the litigation. Therefore, question of reopening his regularization would not arise